Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's topic is, what is the state of things? A discussion with Colorado Attorney General Phil Weiser. In our system of federalism, there are varying levels. The federal government enforces the antitrust laws and the consumer protection laws. But just as importantly, there are state enforcers who serve a very important complementary function to the federal enforcement. Now, we often hear in our section about what the federal enforcers are up to and what are the developments in private litigation. But today we're going to talk to one of the leading attorney generals in the country, someone who is frankly an antitrust expert, formerly with the Antitrust Division, who's going to talk to us a little bit about how antitrust and consumer protection enforcement at the state level plays an important role in the overall enforcement of the antitrust laws. My co-host today is Tammy Zhu. Hi, Tammy.
Hey, John.
Tammy, what are we doing today?
We are talking about the role of states in antitrust enforcement and the role that one state in particular, Colorado, has taken upon itself in the past couple of years. The context here is that over the past few years, states have become more active in antitrust enforcement. For example, in 2019, we saw 20 state attorney generals, including Colorado, investigate and challenge the $56 billion T-Mobile and Sprint merger when the DOJ had approved the merger. In the Google antitrust investigations in October 2020, we saw 7 state attorney generals, including Colorado, issue a statement that they're conducting investigations that are parallel but separate from the DOJ's investigation.
Super. Who's our guest today?
Our guest today is the Attorney General of Colorado, Phil Weiser. He was previously Dean of the University of Colorado Law School and former Deputy Assistant Attorney General at the DOJ's Antitrust Division during the Obama administration. He's been the Attorney General of Colorado for nearly 2 years. In this time, his office has been active in antitrust enforcement. For example, the Colorado Attorney General's office was one of the states that challenged the T-Mobile and Sprint merger when the DOJ did not. The Colorado Attorney General's office reached its own settlement with the parties. Another example is that the Colorado Attorney General's office filed a complaint in the merger between United Healthcare's Optum and DaVita Medical Group, and the office obtained Colorado-specific remedies even when the FTC declined to pursue such remedies. A couple other things include the Colorado Attorney General's office issued a report recently on the increasing prices of prescription insulin in Colorado's concentrated insulin market and issued a set of recommendations. Phil Weiser frequently writes and speaks about the role of states in antitrust enforcement.
All right. Well, it sounds like he's been busy, but let's bring in our guest, Phil Weiser. Welcome to our program.
John, Tammy, so great to be with you guys.
Great. Attorney General Weiser, you've played an active role in enforcing antitrust laws and promoting competition for the residents of Colorado. In your experience, what advantages have you seen states like Colorado have in enforcing antitrust law as compared to your federal counterparts? And can you illustrate that using any recent examples?
The role of the states is special. It does perform picking up the slack function. The feds may overlook certain matters. They may not have the resource to do something. We also have a closer to the people advantage. And so we get to hear directly from people what's on the minds of the people in our state. And finally, we may have a different philosophical approach. And I think in the DaVita case that John mentioned, it was all 3 of those that were at work. We're really concerned about healthcare consolidation, rising healthcare costs. And the insulin study you mentioned, Tammy, that reflected a lot of engagement we had. We did a survey with people who are relying on insulin, and they said that rising cost of insulin has led as many as 40% of people to have to self-ration their access to insulin. That's a pretty startling statistic where people are, in some senses, going to have to fast to manage their blood sugar so they can afford not to take the drugs, which otherwise, if they, try to just go off them without fasting, they may find themselves in the hospital. So that's a pretty startling statistic. So healthcare is on our minds, and we had this case involving United Healthcare that was buying DaVita's clinics, and it was a threat to the Medicare Advantage market where we had three main players in Colorado Springs. If this merger had gone through without any oversight, we were really concerned about Humana, who'd been an upstart rival there, being squeezed out because Humana had relied on DaVita for referral. So we took action by ourselves. In that case, the FTC didn't choose to take action. We did have a couple FTC commissioners praise us for acting. And then we also led the way in some vertical merger comments, talking about how vertical mergers can raise competitive issues that warrant investigation.
Yeah, I do have a follow-up question on the DaVita merger. So in that case, in that merger, we saw the FTC require remedies in another local market in the Las Vegas area. Why do you think that the FTC chose to impose remedies there, but not in like the Colorado Springs local market, and whereas you did?
Tammy, that's really a question for the FTC. I am assuming that they found some element of, call it horizontal overlap in Las Vegas, and they didn't see any horizontal issues in Colorado Springs. It's possible they thought the Las Vegas market was bigger and more notable. One of the points that is interesting from DC, and I literally had some DC person say this, well, it's just Colorado Springs. They're not that big a market anyway, are they? And of course, for us here in Colorado Springs is our second biggest city after Denver. It is, in fact, expected to pass Denver in some 20 years or so. It's a big market. It's growing. And so for us, they matter. And we weren't going to sit lightly. We thought there was a real risk of competitive harm, and we were willing to litigate the merger if we had to.
Great. I want to talk a little bit about the relationship between state antitrust enforcers and federal enforcers today compared to maybe 5 years ago, 10 years ago, 15 years ago. We've seen the states become more active over the past few years. And from your point of view, how is today different from previous state involvement in antitrust enforcement in terms of in what ways or what aspects is the trend different or new from before? And also in what ways is the role of the state's AG's antitrust enforcement similar to those in the past, for example, maybe in the late 90s with the cooperation between states and feds in the Microsoft investigations?
Well, it's a very interesting arc for me because I worked with Joel Klein 25 years ago in the antitrust division, and I got to witness different forms of state cooperation. The Microsoft case was a great model of cooperation, and Tom Miller, who then played a leading role as the Attorney General of Iowa, is still the Attorney General of Iowa 25 years later, and Tom and I have had the chance to now work together. In other matters, the cooperation might have been a little less engaged. For example, there was a merger involving some ski slopes in Vail that I had some involvement with when I was at DOJ. And there, the Colorado Attorney General was really more along for the ride, less of an engaged participant. And if that were to happen today, I think we'd be pretty engaged. And so there's, I do think, a greater premium now than maybe there was then. I also, when I served under President Obama, we worked to engage the states on agricultural issues. I actually joined a conference at Columbia talking about state AGs and agriculture. And then Rich Cordray, Attorney General of Ohio, was involved. Steve Bullock, Attorney General of Montana, was involved. And along with Jim Tierney, many people know in the antitrust world, had been the Attorney General of both, I think, Maine and I'm forgetting what other state he was Attorney General, but Attorney General of two separate states. And so we've tried to have this relationship. I will say what's different, if anything, now is I do think there's a greater level of interest and commitment. The importance of competition in our economy is getting really on the national level discussion. We have a more concentrated economy today than we've had in any time in the last 100 years. And I do think those concerns are making this a more front and center issue.
Attorney General Weiser, you've had to make some choices over time about which cases to bring. I know that you investigate lots of things, and you have to make some choices sometimes about which cases to bring, which cases not to bring. How do you go about making those decisions?
So there are a couple different considerations. Here I'd like to acknowledge our great team. So Steve Kaufman is our deputy of our consumer protection section, and Diane Hazel is our first assistant attorney general antitrust. I should give a quick shout out. We're now looking for a new antitrust lawyer to join our team. So any folks listening, check out. You can go to our website, which is coag.gov, and you can see the posting. You can also look for me or Diane Hazel or Steve Kaufman on LinkedIn and find the posting there as well. The team will work up basically its analysis, and the questions we will ask is, can we make a broader impact? So, for example, one issue that we're looking at, this is not necessarily an antitrust issue, it's a consumer protection issue, but it's an important point to us, is automatic renewals. So we took action against a company called FitTurf where they were signing people up for a lawn service and then automatic renewing people without them even realizing they were getting renewed. And a lot of companies now are tempted to do this. Hey, I've got your credit card. Can I just add on services without telling you? Can I just renew without telling you? We're really worried about that because a lot of consumers don't have the time to be vigilant on top of specific items on their bill. And so they just might pay their bill or have it paid for them and not even realize they're getting charged for things they didn't ask for. So there is an example of a principle that we're trying to pursue. The other topic was, is it in an area that, for example, we think has broad applicability to people? That could really be a concern. Obviously, we talked about the large technology companies and practices there. That's on a lot of our radar screens. And then finally, is it just really egregious? So, for example, price fixing. We see local contractors engaging in price fixing in a way that we believe is just plain wrong and deserves action to hold them accountable. And so that's another reason why we move forward.
One follow-up question I want to add there is one criticism that we've heard of really active state antitrust enforcement is dual enforcement and the inefficiencies of that. How much overlap have you been seeing today between federal and state enforcement today, and what should that interplay or relationship be between state and federal enforcement?
There's a lot there, Tammy. I've written a piece that'll be published soon in the Loyola Law Review that talks about this question of what we like to call cooperative federalism. So at our best, there is cooperation and it's not redundant. That happens in a few ways. One is by having an understanding with the parties and the federal enforcers that we would share documents, for example, to avoid making it more burdensome or redundant. Also, it may be the case that one of us takes the lead. So, for example, on bid rigging type cases, it'll often be the case the states are the ones taking the lead on it. Similarly, in consumer protection, us and the FTC figure out where and how one of us may work more in the driver's seat, the other may be more collaborating. And as we talked about in the United DaVita case, the FTC said, we're not looking at it. So our interest level stepped up and we took the lead on it. So in general, if we're cooperating effectively, I think we reduce the risks of redundant, inefficient oversight. The other point I would make is it's a protection against under-enforcement. And one of the risks we have, I think, in our system is if you have under-enforcement at the federal level, what are the checks on that? In theory, you could have private enforcement of the antitrust laws, although in many cases, particularly mergers, that's quite difficult. And so part of the checks and balances is that states, like we talked about the T-Mobile case, the states can go in and think we want to litigate it. In that case, we had a very dangerous argument made by the DOJ, suggesting if the DOJ passed on something, the state authority should essentially be nullified. And we, in the world of state AGs, those are fighting words. We don't buy that theory at all. And you can see in my lawyer article, I take it on. Ultimately, the courts have to decide if the states decide to move without the feds, are the states right on the merits, and we're not subject to some sort of preemption type doctrine.
We've seen some writing recently, some speeches, including some speeches, I think, from an FTC commissioner that talks about the under-resourcing of the federal authorities. Is there a role for the states to? Is there more sharing that could be done, more cooperation that could be done that could address this under-resourcing at the federal level?
I think the under-resourcing issue is real. If you look at the size of our economy, the size of M&A transactions, and then you see how that's grown from 30 years ago, and then you ask, have the staffs at the FTC and the Antitrust Division of the DOJ grown in a corresponding fashion? The answer is no, which means we are letting more go. And one of the concerns I would say is a lot happens under the radar screen that we don't even realize what's happening, and we're seeing this concentration continue to happen. One example that we know about is the Evanston Hospital merger, where I believe initially that wasn't reported because it was under the reporting threshold. And Tim Uris, when he was chair of the FTC, looked for a case that had happened already. And 4 years after the merger, with 4 years of price data, they then challenged that. And the court, again, looked at the price increases and ruled for the FTC. I don't think that is an exception. I think there are lots of cases out there where something was under the reporting threshold. We had years of evidence, but no one's had the time or resources to look at it. We have not had enough retrospectives. We've not had enough resources. So yes, cooperating and sharing resources between states and the feds is useful, but I don't think it addresses the magnitude of the challenge we have.
I just want to say on the Evanston Hospital that case actually took place when I was at the FTC, and I know that there were staff people that worked very, very hard on the case. But you hit the nail on the head. And it's an interesting challenge because the reason that reversed a long period of losses in hospital mergers for the FTC, I think, and sort of has turned around and rekindled an interest in hospital mergers. I think what's interesting about it is just what you said, which is they didn't have to take on the incipiency issue. They didn't have to prove, that harm was likely to happen. They could show what actually did happen as a result of the merger. This isn't really a state-specific issue, but are you concerned at all about the standards in the courts today? And do those standards need to be changed to address issues like this?
I'm terrified. And part of what I think we're seeing is a overreaction to the Chicago School critique. So initially, the Chicago School critique was of the 1960 standards, where famously a Supreme Court justice said, I don't know what the standard here is other than the government always wins. And that was a critique in a case called Vaughn's Grocery. That world, the Vaughn's Grocery world, is a far, far cry from where we are. Right now, we had a case recently in the Ninth Circuit involving Qualcomm, where a district court judge made careful factual findings, where there was powerful, compelling evidence of monopolistic behavior and exclusion. And the Ninth Circuit overturned it, in my view, relying on very broad, almost philosophical points, suggesting that we should be very cautious to ever interfere in the marketplace. That is beyond what I think the original Chicago School critique showed us. And I think, for example, if you look at Posner, who was a critic of Vaughn's Grocery, he wrote some hospital merger opinions that showed a respect for merger law. And in his piece, Antitrust and the New Economy, talked about the importance of Section 2 in technology industry. So we've gone well past what I think a reasonable Chicago School critique is, and we've had standards that have really made it very difficult for enforcers. If I can mention a second case quickly, John, I think the two are related. The American Express decision is a travesty because what was done in that decision was suggesting that if it's a two-sided market, you can't simply focus on harms on one side of the market, but you have to try to look across both sides of the market, which can often be mission impossible for the enforcers, thereby, again, sidelining enforcers. So I worry a lot about cases like the Amex case, like the Qualcomm case, and the degree of difficulty that enforcers are then having to face. And finally, what this all does is it undermines the teachings of a case like Evanston, where facts and empirical realities mattered. If you can take abstract concepts and use them to deny looking at empirical reality, I think you've really undermined antitrust.
Yeah, it's that fear of the type 1 error, right? That we might get one wrong and over-enforce in one case that we should make sure we don't enforce in 100. I think that's the argument. Is
That's
there an
right.
opportunity? Is there an opportunity for you to use state law to try to come up with standards that you think are more appropriate?
In theory, that is a way we could go. Historically, we've not seen state antitrust law differentiate itself too much from federal antitrust law. Illinois BRIC is probably the biggest example one can come up with where state antitrust law has taken a different path. But on substantive Section 2 or monopolization standards, I do think a much better world would be we see the courts rethink this direction that we've seen. I do think the House antitrust report, taken broadly, is a little bit of a shot across the bow, suggesting to the courts there's a role for Section 2. And the monopolization case in Microsoft is a good example of what responsible Section 2 enforcement looks like. I do think that is in contrast to the Qualcomm decision. And I do hope the courts can get to the right place. We haven't had to see Congress too often step in and shape substantive antitrust standards. In general, I think the system we have has worked very well, where the courts have been able to respond to economic learning. And when I read cases like Qualcomm or American Express, I worry about the state of antitrust doctrine.
Great. Yeah. In terms of, I think one of the issues that has that you've highlighted is kind of in the Evanston merger. We saw that on hindsight, the FTC was able to gather price data and that information to make a stronger case. I was wondering that earlier when you spoke about cooperative enforcement between the feds and the states. What kind of information sharing have you been seeing, and what should information sharing look like between federal and state investigations?
In general, the feds have been great to work with, both the DOJ and the FTC. In the case we talked about earlier, the DaVita United Healthcare case, the FTC was very willing to share information with us. Even though they weren't moving forward, they were cooperative, and they didn't want us to have to redo work they'd done. They had an open dialogue. And in a number of cases, that open dialogue, I believe, makes both of us better. And what has been, to my mind, very reassuring is that dialogue has come from a place of respect. And this is part of what the changing legacy John referred to. At times, the states had been thought as sort of the junior varsity, not taken as seriously. I have not experienced that in terms of my work with both the FTC and the DOJ. And I believe it's on us as states to really do professional, high-quality work that doesn't lend, let's say, the concern that we're not at the equal of the federal government. And that is, I believe, part of what could lie behind the criticism that Macon Delrahim made when he talked about the state's actions in the Sprint T-Mobile case. There was also a time when Judge Posner, after the Microsoft case, was critical about the states in antitrust law as well. And that's something that I take as a challenge that we have to own. How do we do better? How do we push ourselves to demonstrate that we are adding real value and bringing a great standard of rigor forward?
You know, it's funny. It's funny to hear you say this because, and I'm going to ask you for your thoughts on the history of this. But when I started practicing a long time ago, and you would have a merger that involved the states, oftentimes what you were doing is figuring out how you were going to fix it with the DOJ or the FTC, and then going to the states, giving them something local that they could point to, generally a remedy that didn't mean very much, paying the attorney's fees of the state enforcers, and calling it a day. That was a long time ago. There were exceptions to that, of course. There were always certain states that were very aggressive, but there were at least a handful of states that took that philosophy on. Today, I don't think that is the case at all. Today, I think if you, as a defendant, as a merging partner, at your peril, will you ignore the states and not treat them as, very important players, very important partners in the merger investigation? I think it's a change. Attorney General Weiser, do you agree? Is this a change? And if so, what brought it about? Why have the states, frankly, why has the quality of the game in many, many states increased in the last few years?
I think a big part of it is people like Diane Hazel, who had been at the FTC, practiced with elite firms, going to join working in state government and taking antitrust enforcement seriously. When you have that level of crossover, former FTC or DOJ staffers, indeed in our office, not only Diane, but Steve Kaufman, who had practiced at a very high level. And then we've even brought on board former colleagues of mine from the DOJ, John Salad and Jeff Blattner, to work with us in cases. So we've really been able to attract top talent. And I think that's a key part of it. And I'll tell you, these people in my office, it's not like that is the exception. We are working in multi-states in different arrangements. There are incredibly talented antitrust lawyers all across the U.S., Virginia, Ohio, Nebraska, obviously I mentioned Colorado, and obviously, of course, New York and California. But part of what's different is it used to be, well, okay, maybe New York or California, but nobody else. The so-called flyover states, which include Nebraska, Colorado, maybe even Ohio, were overlooked. Just like you said, John, you overlook any state at your peril because we've recruited great people to work in these offices who take antitrust seriously.
And then last substantive question for you, Attorney General Weiser, what do you think are the most important things, either for you as an office to tackle or for the states as a whole to tackle in the near to midterm? What are some of the really looming issues that the states need to be addressing?
So there are a range of different matters. I do think we've got to be very vigilant on the merger enforcement front, given the level of concentration in our economy. And I don't want us to be doctrinaire, for example, not looking at any vertical mergers, I think would be a mistake. And obviously the case we talked about earlier was a vertical merger. We also need to be thinking hard about Section 2. Part of what has been a challenge is the law in this area has made it difficult for enforcers. So I do want us to keep an eye out for how we can help develop and defend Section 2 as an important principle. The monopolization concept is still real. I think that we're seeing new, different challenges in the economy. Big data is a big challenge. How do we think about data is something that's continuing to get discussed. Part of the challenge also is we have no federal data privacy regime. When I worked under the Obama administration, we proposed a privacy bill of rights. We're now seeing states in the lead in this area. We in Colorado looked at legislation last year. We may again. So there are a range of different issues that cut across industries that are going to be on our radar screen. I wouldn't pick just one or two, but I would say that broadly we're going to remain vigilant and continue to do our work.
All right, well, let's shift gears a little bit. And let me ask you probably the hardest question you're going to be asked on today's program. Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
Well, if you read my bio, and even if you followed me on Twitter, you would not know that I was a play-by-play announcer when I went to college, doing both football, basketball, and baseball games. I went to a small college, Swarthmore College, where I could do that sort of thing. So I had a path not taken of being a radio broadcaster, and maybe in some other universe, that's what I went on to do.
Have you ever given thought to being a podcaster? Because I'm told it's not all that hard.
Well, you guys are doing a great job.
And more seriously, and referring back to your bio, you've taken many different paths, right? I mean, you've worked in the federal government, you've clerked, but you've also worked in academia. What advice do you have for young lawyers and young economists who are sort of just starting out about how they should manage their career and how they can get the best experiences?
Chase experience. So, for example, there could be lawyers in DC right now who are thinking about their future. Why not think about coming to a state like Colorado to work as an antitrust lawyer in a state AG's office? Why not think about working in-house at a company that might be a little bit different than your current path? Part of the problem for young lawyers is if you think of life as a linear track, I went to high school, got good grades, went to college, got good grades, went to law school, got grades, got a clerkship or went to a big firm, and you just think that is sort of a track that you're supposed to just stay on, you're missing the boat. You can think about life instead as a choose your own adventure, be creative, take smart risks along the way, and I believe you'll be better for it.
If you had to choose just one of those experiences in your bio as perhaps the most formative, What would it be?
My first clerkship with Judge David E. Bell out here in Colorado. So my life, John, you and I both were at NYU Law School together. And when I graduated, if you said, Phil, you'll be Attorney General in Colorado someday, I'd be like, you're smoking a drug that's now legal out here. Because I didn't really know much about Colorado. And it was only my willingness to follow a mentor, Chris Eisgruber, who now is president of Princeton University, said, Phil, the best job you can get when you graduate is a clerkship. He said, apply for clerkships in any city you could live in. And so for me, I looked at cities with a Jewish community and a baseball team. And Denver was on the list. So I applied to work with Judge David E. Bell, and I fell in love with Colorado, which, again, for those of you who come out here, you may realize this is an incredible place to live. So I thought, wow, what a great idea if I could live here. And then I got another clerkship back in D.C. and got this chance to work in Antitrust Division, and then heard about this job in the law faculty at CU, which was joint appointed with the telecommunications program. So I gave that a shot because it was a way to come back to Colorado. But if I hadn't had that first clerkship in Colorado, it wouldn't have opened my eyes to Colorado. Plus, as a mentor, David E. Bell was truly exceptional in terms of just teaching and caring about me as a person. He even set me up with my wife.
So that would be the most formative experience, without a doubt. I do want to go back, and I should have disclosed at the beginning, you and I did go to law school together. And I do want to disclose to the listeners, while I may not have said Attorney General of Colorado, I mean, your commitment to public service goes back, however long it's been, 25, 26 years, longer. How was it that you got, and you and I actually did some public service, you turned me on to some public service project. How was it that you got, what was it that pushed you towards public service?
Particularly running for office, I've had to think a lot about this because my whole career has been about service. And I do think it comes from my family history. So I've talked a lot more about this actually since becoming an elected official. My grandparents are Holocaust survivors, and my mom was born in a concentration camp in Nazi Germany in 1945. And they chose to come to the United States of America because they believed that this would be a land of opportunity where they would be treated fairly, equally. And my mom went to then City College for free and had the chance to become a teacher and married my dad. And they both were first generation going to college. And so I felt like the United States has given me so much and our freedoms mean so much that serving in a position where I could fight and protect for people has always been meaningful to me. And so I've not chosen more lucrative paths, but I've chosen to do service work, which I've always found to be my calling. And I think that's largely what's driven me and continues to drive me.
And I found, again, I was, as you kindly agreed to come on the show, I reflected back to our experience together. And the project we worked on together was a very, very local project involving school children and teaching them debate skills. Something I had not really been involved with, but what I found, it wasn't sort of the big splash necessarily, but it was incredibly meaningful. And I think sometimes those smaller projects where you can make an impact on a small level are so important.
I totally agree, John. And I would encourage people who want to be involved in service, look for a community-based organization to work with, or your local government or your school board, or even state government. The national government, I've served under 2 administrations. It's a phenomenal chance to make a difference, but it does lack that connection to people. And even doing antitrust work here in Colorado, Diane Hazel led an effort that involved a bid rigging case where part of the settlement involved supporting a homelessness initiative, people living in tiny villages that could help move people out of homelessness and into a more stable living environment. That's a way to make a difference here locally in real people's lives. And we keep looking for those ways at the Colorado Attorney General's office.
Great. All right. Well, let's go to our final subject, which we call the Curious Hat.
And now it's time for the Curious Hat.
In my right hand, I have a series of questions. Now, if we were all together, I would have a hat. In the hat would be a series of questions. I would hand you the hat. You would pull a question out of the hat, and that would be the question we would read. Because we are not together in these times, I have a series of questions on a piece of paper. They are numbered from 1 to 25. I would like you to choose a number between 1 and 25, and I will read the question that corresponds with that number.
16.
Okay, question 16. All right. Do you have any networking tips or particular ways you enjoy keeping in touch with those you've met during your career?
I get a version of this question a lot. One of the versions is, how can you be an effective mentee? And I do it more organically, so I'm not as good at this as some. But part of what I would just say in the organic is, as you think about somebody in some shared connection, reach out to them. That's the organic model. But you've got to be disciplined and do it. So if you're both a St. Louis Cardinals fan and they get to the World Series, then reach out. If you're thinking about an issue that you worked on together, the Evanston Hospital case, then reach out. That can be very meaningful because you reconnect with somebody and it's around a shared connection. Too often people don't reach out until they need a reference or help. Right. And that's a mistake, because then you're not keeping that relationship alive. And I'll tell you, some people said to me, how did you manage to have this great group of supporters that helped you win this race? The answer is authentic relationships. Just keep in touch with people in a way that you're not asking for someone every time you reach out.
I know this is going to sound a little bit strange, but my experience has been, be a little less strategic.
Yes.
I wish I had kept in touch with some of the people that I've met who have gone on to incredible heights. But the people that I've kept in touch with have generally been just good people with whom I have a connection. And one will be surprised how often something very meaningful comes out of those sorts of relationships. And that could flow both ways, right? Because you can have a peer where you can help them, and that's also a very good feeling. Plus, if it's, as you say, if it's a truly an authentic relationship, then the person will be able to act in a very impactful and meaningful way for you.
Amen.
What about the flip of that question? What are some ways that you've been an effective mentor, or strategies for being one?
I think being an effective mentor is about having a authentic relationship with someone where you're learning from them as well as them learning from you. And so you want to get to know the individual as a person, and you need to be present with them as they are confronting whatever situations they're confronting, and are comfortable talking to you about their life choices. It's very meaningful for me when people who've been mentees get back in touch, just like Judgy Bell was to me, and saying, I'm facing this decision, I'm trying to figure out how to handle this. That's meaningful. And for those people out there who are mentees, you need to know that your mentors appreciate you being in touch with them.
Attorney General Weiser, thank you for coming on our program today. And for those listening, until next time, we will see you on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.